Speaker. I rise to speak on the Terrorism and Other Legislation Amendment Bill 2025. I begin by acknowledging the seriousness of the events that have led to this bill being brought before the House. Acts of terrorism and violent extremism strike at the heart of our social cohesion and our sense of safety. Parliament has a duty to respond and to ensure our laws properly equip police and security agencies to protect the community. And let me state at the outset, the Coalition, the Liberals and Nationals, have approached this sitting constructively and responsibly. We recognise the seriousness of terrorism, extremism and threats to community safety, and we do not shy away from taking firm action where it is genuinely required. However, this is a large and complex cognate bill, spanning terrorism offences, firearm regulation, protest and public assembly powers, and summary offences. It is precisely the kind of legislation that demands careful drafting, genuine consultation, and proper parliamentary scrutiny. On those tests, the Minns government has fallen short. An exposure bill was only provided to the Coalition late on Saturday afternoon, with debate scheduled almost immediately. Stakeholders, including law-abiding firearms owners, small businesses, civil liberties groups, and faith communities, have been given little or no opportunity to engage meaningfully. At a time when government calls for unity, it has instead chosen to rush legislation through Parliament and then ask questions later. That is not good lawmaking, and it is not respectful of this Parliament. The government's own drafting gives this game away. Significant elements, particularly in relation to firearms, are to commence by proclamation, not immediately. That alone demonstrates there was time to do this properly, to consult properly, and to produce better law. Over recent days, I have had a number of conversations with individuals, shooting clubs and businesses. Indeed, just 5 minutes before coming into this chamber, I was in a phone conversation with one of my former constituents. I appreciate the genuineness of each of those discussions. This is reinforced by my own background coming from the land and by the many people I know personally who are involved in recreational hunting or organised shooting sports. For those who live in metropolitan areas, firearms may be viewed primarily through the lens of crime or public safety risk. In regional New South Wales, firearms are also a legitimate and highly regulated tool of trade and land management. Farmers and primary producers rely on them for pest animal control, livestock protection, biosecurity and animal welfare. Recreational hunters play a recognised role in pest control, conservation programs and regional economies. These realities must be understood if legislation is to work on the ground. The overwhelming majority of recreational shooters in New South Wales are law-abiding, decent, ordinary Australians. They comply with strict licensing, storage and safety requirements. They are not the problem, and they should not be treated as collateral damage of rushed reform. Nor should we forget the small and generational firearms businesses, many in regional New South Wales, who do the right thing every day and who will be cruelled by poorly considered changes that threaten their livelihoods. Speaker, I note the member for Monero's contribution, and he spoke of the role of regulation and also of the importance of having a well-funded, a well-resourced registry. I agree with him on both of those comments, and will make it known that we need to hold the government to account on these matters. Speaker, in 2019, the New South Wales Auditor-General conducted a detailed performance audit of firearms regulation in this state. One finding is particularly relevant to this debate. The Auditor-General found that the Firearms Registry was not adequately assessing the validity of reasons provided by licence holders when they apply to acquire firearms. Under the Firearms Act, a person must demonstrate a genuine reason to hold a firearms licence, but to acquire each additional firearm, the Act requires something different and more stringent, namely that the applicant demonstrate a good reason. These are not the same legal tests. Parliament deliberately set a higher bar for acquisition than for licensing. The problem identified by the Auditor-General was not that the Parliament lacked power, it was that the Registry lacked clear guidance on what constitutes a good reason, consistent administrative policies, and robust scrutiny of individual acquisition decisions. Speaker, there is much that good reform intent could explore in this space. That is an administrative and governance failure, not a failure of the legislative framework. Instead of fixing that failure by strengthening discretion, clarifying the good reason test, and improving risk-based assessment, the government has chosen a different path. If the firearms registry is not properly assessing why someone needs an additional firearm now, then simply imposing arbitrary limits does nothing to address the underlying risk identified by the Auditor General. It merely shifts the burden onto those who are already doing the right thing. This is not smart regulation. It is regulation that avoids judgment by replacing it with blunt instruments. There is also a glaring inconsistency in the government's approach to procedural fairness and appeal rights that must be addressed. I note that in the initial exposure draft, government was intending to remove the right to NCAT, and they have restored that in the current bill, and for good reason. Because in September 2025, during the debate on the Justice Legislation Amendment Miscellaneous Bill 2025, the government told this Parliament that access to external review through the New South Wales Civil and Administrative Tribunal was so important that it needed to be restored even for children. We were told that firearms prohibition orders are serious and wide-reaching, that they can authorise police to search a person at any time without a warrant, and that they have no expiry date. On that basis, at that point in time, Labor argued that it was essential that those subject to such orders have access to independent merit reviews through NCAT. To see that that was removed in the exposure draft, that ability to approach NCAT, just raises questions. It's certainly one that the government has already recognised, and again, in its haste, has had to restore in this legislation. In my view, Speaker, with regards to Schedule 2 in terms of dealing with the firearms, reform would have been far better directed towards strengthening the fit and proper person test and tightening the discretions available to the Commissioner. Better consultation by the government would, I believe, have resulted in better legislation. Turning to Schedule 1, which creates a new offence for displaying prohibited terrorist organisation symbols, the Coalition has been clear and consistent in condemning hate symbols and extremist ideology. Yeah. Earlier this year, we introduced the Crimes Amendment Display of Nazi and Terrorist Symbols Bill 2025. That legislation was blocked by Labor. Now, only months later, the government brings forward its own version, narrower in scope, lower in penalties, and rushed through as part of a much larger bill. The community is entitled to ask why the Coalition's bill was unacceptable then, but a diluted version acceptable now. And if the government truly believes this conduct is as serious as it claims, why does its response fall short of the framework it previously opposed? Consistency matters, credibility matters. Speaker, the bill also contains significant expansions of police powers relating to protests and public assemblies, particularly through expanded face-covering powers and new public assembly restriction declarations. Only earlier this year, during debate on the Crimes Amendment Places of Worship Bill 2025, the government rejected Coalition amendments dealing with mass protests and public safety. Yet now, through a different legislative pathway, the government advances broader protest controls, again with limited consultation and under the banner of urgency. Public safety must be balanced carefully with the right to lawful assembly. That balance requires transparency, consultation and restraint, not rushed lawmaking. Speaker, I seek just a very short extension, please.
The question is the member's time be extended. All that opinion say aye.
Aye. Thank you.
5 minutes.
Speaker, finally, these changes alone will not stop terrorism or radicalisation. Without serious action on intelligence, counter-terrorism and social cohesion, these reforms risk being more about political theatre than genuine prevention. I support calls for a Royal Commission, but I also recognise that that is where our focus needs to be. Good lawmaking, particularly in areas as sensitive as terrorism and firearms regulation, requires care. Acting too quickly risks creating laws that are difficult to administer, costly to comply with, and ultimately ineffective in addressing the very threats they are designed to counter. The Premier has said that these changes must pass, and whilst I acknowledge that call, on behalf of my community, I urge the Premier to recognise that if the government genuinely wants unity, it must first demonstrate respect for Parliament, proper process, and the people who will live with the consequences of these laws. Thank you.